3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files.
It's good to be here.
The central mystery of this entire saga isn't just about the crimes committed. We know about the abuse. We know, about the network.
Right.
The real mystery, the one that keeps people up at night, is the legal system's initial failure. We're talking about a mountain of evidence, dozens of victims, and yet the initial response from the machinery of justice was, well, it was silence, and then it was leniency.
It's the question that hangs over everything. Why did the wheels of justice, which usually grind so fine for the average citizen, grind to a complete halt for one man?
Exactly. Some prosecutors pursued the case, some didn't. Today we examine the prosecutors who fought for justice.
And who walked away.
And what happened to their careers after.
We are going to map out the trajectory of the legal battle. We'll look at the specific prosecutors involved in those early decisions, the heated internal debates revealed in the Department of Justice documents, and that infamous non-prosecution agreement, the NPA, that baffled legal experts for over a decade.
And we'll finish by looking at the pivot. The moment a new team of prosecutors years later decided to tear that agreement up. So let's not waste any time. Let's dive in.
We have to start with the smoking gun of the legal failure, the 2008 non-prosecution agreement.
Right. This is often referred to as the deal of a lifetime. And frankly, when you actually sit down and read the terms, it feels less like a legal agreement and more like a get-out-of-jail-free card. I've got the text of it in front of me, and it's still shocking.
It really is an anomaly in the legal world. In the files we've analyzed, specifically the documents reviewing the history of the case, there is a lot of discussion about this NPA. Now, for everyone listening, we should probably clarify what a non-prosecution agreement usually is, because this isn't something you see in your average criminal case.
Okay, let's unpack this. Because usually when I hear a non-prosecution agreement, I think of a corporation, right? Like a massive bank gets caught looking the other way on money laundering, or an energy company cooks the books. They pay a massive fine. They agree to fix their compliance department, and the government agrees not to press criminal charges because putting the company out of business would hurt the economy.
Precisely. It is a tool typically reserved for white-collar corporate crime. It gained popularity after the Arthur Andersen case, the accounting firm that collapsed after Enron. The government realized that, indicting a company is a death sentence for the company. So they created these NPAs to reform the entity without killing it.
So the logic is, we want you to behave better, but we don't want to destroy you.
Correct. But here is the critical distinction. It is almost unheard of to apply an NPA to a sex offender, let alone a sex trafficking ring involving minors. You can't reform a sex offender's compliance department.
Right.
You can't monitor their business practices to ensure they aren't abusing children.
So applying a corporate loophole to a human predator is already bizarre. But it wasn't just that Epstein got off easy. The language in this document, it's breathtaking. It didn't just protect Jeffrey Epstein.
No. And this is the part that enraged so many observers and victims later on. The agreement contained a clause that provided immunity to any potential co-conspirators.
That is wild. I want to read the specific phrasing here because it sounds like fiction. It says, the United States agrees not to prosecute any potential co-conspirators of Epstein, including any potential co-conspirators seeking immunity. It's essentially a blanket immunity for anyone who might have ever met the guy.
It effectively shut down the investigation into the entire network. Think about the implications of that sentence. By signing that document, the federal government agreed not only to stop looking at Epstein, but to stop looking at anyone associated with him. The pilots who flew the planes, the recruiters who found the girls, the wealthy friends who visited the island.
It's a force field.
It tied the hands of the FBI and future prosecutors. If an FBI agent found evidence that a recruiter named, say, Jane Doe had trafficked a girl across state lines, this piece of paper, signed in Florida, could theoretically be waived in court to say, sorry, you promised not to touch her.
But here is the disconnect that I found in the files. We have documents showing that the prosecutors, the people on the ground, knew this was a serious case.
They absolutely knew.
There's a memo where prosecutors alleged that the sentence should be extensive. They were looking at a life sentence, essentially, or at least decades. And yet the agreement resulted in, what, 13 months?
13 months in a county jail with work release for 12 hours a day, 6 days a week.
So let's be clear about what work release means here. This wasn't picking up trash on the highway.
No, not at all. This was him leaving the jail in the morning, being driven by his own driver to his office in West Palm Beach, spending the day there, where, by the way, he was allegedly visited by young women, and then returning to the jail to sleep.
So he was basically sleeping at the jail and living his life during the day?
Correct. And we have to ask why. Why would federal prosecutors, who had a 53-page indictment drafted, we know this from the files, why would they trade that for a 13-month slap on the wrist?
The files give us a clue, don't they? There's a reference to a prosecutor discussing the realistic likelihood of conviction and, interestingly, the public interest.
That phrase does a lot of heavy lifting here. Public interest.
Right. How do you determine that prosecuting a prolific sex ring isn't in the public interest? I mean, isn't protecting children the definition of public interest?
That is the central debate. The argument made by the U.S. attorney at the time, Alexander Acosta, was that this was a guaranteed way to get some registration as a sex offender. He argued that taking the case to trial was a gamble.
A gamble?
Yeah. The victims were young, their stories varied slightly, as trauma often causes, and he feared a jury might not convict.
So the logic was better to get him on something small than risk him walking on everything.
That was the stated logic. Acosta has consistently maintained that he was playing 4D chess, that state laws were weaker, federal laws were tricky, and securing a plea that forced Epstein to register as a sex offender was a victory.
But hold on, is that a valid fear? I mean, you're the expert here. Federal prosecutors have a conviction rate of something like 90+%. They don't bring 53-page indictments unless they are sure. Was this case actually that flimsy?
That's where the public interest argument falls apart for many legal scholars. The FBI had raided the house.
They had the evidence.
They had the massage logs. They had corroborating witnesses. This wasn't a he said, she said. This was a he said, and the physical evidence and 20 other people said situation.
So the fear of losing argument feels thin.
Extremely thin. The files suggest a different story. They suggest a deep reluctance to engage in a messy, high-profile trial against a defendant with unlimited resources. It wasn't about whether they could win. It was about whether they wanted to endure the fight required to win.
And that leads us to the jurisdictional shuffle. This is another thing that pops up in the documents. The tension between the federal prosecutors and the state prosecutors in Palm Beach County.
Yes.
Because you have two different sovereigns here, right?
This is crucial to understanding how the deal went down. You have the U.S. Attorney's Office, the feds, and the state attorney's office. Now, normally, under the concepts of dual sovereignty, both can prosecute you for the same act if it violates both state and federal laws.
So the feds could charge him with sex trafficking across state lines, and the state could charge him with solicitation.
Exactly. But the files show the feds effectively abstained. They handed the case down. They essentially said, we are going to step back and let the state of Florida handle this.
It's like a hot potato. We don't want this. You take it.
In a way. But it was more calculated than that. The document notes that the decision was to allow the state to handle the prosecution. But by doing that, they allowed Epstein to plead to state charges, solicitation of prostitution, rather than federal sex trafficking charges.
Which carry vastly different sentences.
Night and day. Solicitation is a misdemeanor or a low-level felony. In Florida specifically, it can be very minor. Sex trafficking is a major federal crime with mandatory minimums that can put you away for life.
So the jurisdiction matters.
It matters immensely. By handing it off, they ensured the lighter sentence. They took the teeth out of the prosecution. And remember, the Mann Act, the federal law prohibiting transporting people across state lines for immoral purposes, was designed exactly for this.
Right.
The feds had jurisdiction. The victims were flown in from New York, from Europe. This is a federal case by definition.
And that consequence rippled out for a decade. It allowed him to continue his life, effectively. But let's zoom in on the people, because the government didn't make this decision. Specific people did.
That's right. Institutions don't make choices, individuals do. And inside the DOJ, it wasn't a monolith.
The files mention 20 or 30 line attorneys. Can you explain what that means? What is a line attorney versus, say, Acosta?
Yes. And this distinction is vital. In the U.S. Attorney's Office, you have the line attorneys. These are the career prosecutors. They are the ones interviewing victims, building the case files, doing the grunt work.
Okay.
They aren't political appointees. They're there to prosecute crimes, usually for decades. They are the engine room.
And then you have the boss.
The U.S. Attorney, in this case, Alexander Acosta. He is a political appointee. He is nominated by the president and confirmed by the Senate. He makes the final call. His job is legal, yes, but it is also inherently political. He has to weigh resources, public perception, and policy.
So was there friction? Did the line attorneys agree with this deal?
The evidence suggests significant internal friction. The files refer to prosecutors who declined to prosecute versus those who pushed forward. There is a sense in the documents that the recommendation from the line prosecutors, the ones who knew the case best, was to go hard. They had the indictment ready. They had looked the victims in the eye.
So you have the people who did the work saying, let's get him, and the boss saying, let's cut a deal.
Precisely. The boss pivoted to the deal. And this creates a huge morale issue. Imagine working for 2 years on a case, gathering evidence of horrific abuse, and then your boss comes in and says, we're going to let him go with a warning.
And we touched on Acosta's defense, that he was afraid Epstein would walk. But looking at the files, there is this phrase, disparate treatment. It suggests that federal prosecutors treated this case differently than they handled other similar cases.
That is the key indicator of something going wrong. In law, consistency is everything. If you have a standard operating procedure for drug dealers or bank robbers or other sex traffickers, and then suddenly, for this defendant, you throw out the rule book and invent a new type of agreement, that is disparate treatment.
Why, that's the question. Was it just fear of losing? Or was it the person on the other side of the table? Because Epstein didn't just have a public defender, he had a dream team.
He had the legal Avengers.
Yeah.
Kenneth Starr, the man who investigated Bill Clinton. Alan Dershowitz, the Harvard professor. Jay Lefkowitz. These were titans of the legal industry. These are guys who don't just know the law. They know the judges, they know the prosecutors, they know the politicians.
And the files show they played dirty. Or let's say they played incredibly aggressively. This wasn't just a polite disagreement in court.
They did. We see documents regarding Alan Dershowitz's attempts to disqualify the prosecutors. This wasn't just, my client is innocent. This was, the people investigating my client are corrupt, biased, misbehaving.
It's a strategy called investigating the investigators.
Exactly. They turned the heat back on the U.S. Attorney's Office.
Yeah.
They filed complaints against the prosecutors personally. They dug into their backgrounds. They made it personal.
I want to spend a moment on this because it feels like a thriller movie plot. We're talking about private investigators looking into the lives of federal prosecutors.
Yes. The defense team reportedly hired private investigators to dig up dirt on the prosecutors and the investigators. They looked for anything. Marital problems, financial issues, past professional complaints. The goal is to create leverage. If you can threaten a prosecutor's career or reputation, they might become much more willing to settle.
That has to have a psychological effect. If you're a prosecutor and suddenly your own career is being threatened by the most powerful lawyers in the country, maybe you start looking for an exit ramp.
It creates an environment of siege. The U.S. Attorney's Office felt under attack. The files reflect this siege mentality. And in that context, the MPA looks less like a strategy for justice and more like a peace treaty to end a war they were tired of fighting.
There's this one handwritten note in the files that really stuck with me. It just says, pitch to other prosecutors, book deal.
That is a fascinating artifact.
What does that even mean, book deal?
It's ambiguous, but in the context of the defense's aggression, it likely reflects the defense team's attempt to impugn the motives of the prosecutors.
Yeah.
They were suggesting that the only reason the police and prosecutors were going after Epstein was to get famous, to write a book.
So they were gaslighting them. You don't care about justice, you just want fame.
Precisely. It's a classic deflection tactic. If you can paint the accuser, or in this case the prosecutor, as greedy or fame-hungry, you undermine the credibility of the case. And when you see that note scrawled in the file, you realize how deep that psychological warfare went. It wasn't about the evidence anymore. It was about the motives of the people bringing the charges.
And it worked.
It worked. The prosecutors blinked.
So 2008 happens. The deal is signed. The victims are left in the dark. We'll get to that in a minute. And Epstein walks with a slap on the wrist. For 10 years, that was the end of the story. It was the lost decade.
Until it wasn't.
Enter Julie K. Brown.
We cannot overstate the impact of journalism here. Yep. The legal system had closed the book. The FBI had moved on. But Julie K. Brown at the Miami Herald didn't. Her reporting, specifically the series Perversion of Justice, exposed the 2008 deal to the sunlight.
It's amazing, right? The documents were there, the deal was done, but nobody really looked at it until she did. She dug it up.
She went back and found the victims. She laid out the terms of the NPA. And when the public saw it, in black and white immunity for co-conspirators, no federal charges, the outrage was universal. It forced the Department of Justice to look in the mirror.
Yeah.
You have to remember, this was post-Me Too. The tolerance for this kind of sweeping immunity for sexual abuse had evaporated.
And this brings us to the resurrection, 2019, a new team of prosecutors. The Southern District of New York, SDNY. Now, SDNY has a reputation, right?
The Sovereign District, as they are sometimes jokingly called, they are known for being independent, aggressive, and incredibly sophisticated. They handle the biggest financial crimes, terrorism cases, and organized crime. They don't take orders easily.
So how did they get around the deal? I mean, a contract is a contract, right? If your government signed a deal in 2008 saying we won't prosecute, how can they prosecute in 2019?
That was the central legal battle. Epstein's lawyers waived that 2008 paper and said, you promised. They argued that the United States had signed the agreement and SDNY is part of the United States, so they're bound by it.
Which seems logical, honestly.
It is logical.
Yeah.
But SDNY found a loophole. Or rather, they enforced a specific reading of the document. They argued that the U.S. Attorney in the Southern District of Florida did not have the authority to bind the U.S. Attorney in the Southern District of New York.
Oh.
They argued that the agreement was regional, not national.
The New York isn't Florida argument?
Basically. They said, Acosta signed for Florida, he can't sign for us. It was a bold move. It's not legally watertight. There's plenty of debate about it. But they were willing to take the risk.
It feels like a technicality, but thank goodness for it.
It was a fierce legal fight. The files describe federal prosecutors as fighting to throw out the lenient agreement. They had to effectively argue that their own colleagues in Florida had overstepped their bounds back in 2008.
They had to throw the previous prosecutors under the bus.
To save the case, yes.
And then, of course, Epstein is arrested. But then he dies. The files reference it as suicide, though I know that's a whole other deep dive we could do.
The official determination was suicide. But from a prosecutorial standpoint, his death presented a massive problem. You can't prosecute a dead man. The criminal case against him evaporated the moment he died.
So the target shifted.
To Ghislaine Maxwell.
The files referred to her in very stark terms. Epstein pimp Ghislaine Maxwell.
With Epstein gone, she became the proxy for justice. The prosecutors needed to prove that this wasn't just one man acting alone, but a conspiracy. And the 2008 deal, remember, was supposed to protect potential co-conspirators.
So they had to break that deal to get her, too.
Exactly. And they did. The strategy shifted entirely to holding her accountable for facilitating the abuse. The files show a long-term plan. A possible Maxwell prosecution was on the radar, but it became the primary mission after Epstein's death. They had to prove she was an active participant, not just a bystander covered by immunity.
And she got 20 years, a far cry from 13 months on work release.
It was a vindication in many ways of the victim's testimony. It proved that if a jury actually heard the evidence that Acosta was afraid to show a jury back in 2008, they would convict. It proved that Acosta's fear was unfounded.
Let's talk about the fallout. Because if I screw up this badly at my job, I get fired. If I sign a contract that gives away the farm, I'm out. What happened to the prosecutors who signed the deal of a lifetime?
Well, Alexander Acosta went on to become the Secretary of Labor in the Trump administration.
Which is a pretty high promotion.
It is. But when the Epstein case resurfaced in 2019, thanks to the Miami Herald, the scrutiny on that 2008 deal became intense. Acosta held a press conference to defend his actions, repeating the argument that he got the best deal possible at the time.
But the public didn't buy it.
No. The dissonance was too loud. The public saw a sweetheart deal for a billionaire and a cabinet position for the prosecutor. He eventually resigned from the cabinet.
But was there punishment? Legal punishment?
The Department of Justice conducted an internal review. The Office of Professional Responsibility, or OPR, they looked at professional misconduct. And this is where it gets frustrating for people looking for accountability.
Uh-oh.
They found poor judgment.
Poor judgment. That's like saying, oops, my bad.
They explicitly concluded that while the decision-making was flawed, it didn't rise to the level of professional misconduct that would warrant disbarment or prosecution of the prosecutors. They said he exercised his discretion poorly, but exercising discretion is part of the job.
That seems incredibly convenient.
It highlights the broad immunity prosecutors enjoy. It is very, very difficult to punish a prosecutor for making a bad deal as long as you can't prove they were bribed or acted with malicious intent.
Right.
Being bad at your job or being outmaneuvered by the defense isn't a crime. It's just incompetence.
But it leaves a bitter taste.
It does. It signals that you can fail upwards, even on that failure leaves dozens of children vulnerable.
Now, we have to talk about the politics, because you can't open these files without seeing the names.
It's a minefield.
We see references to Bill Clinton, we see references to Donald Trump.
And it's important to look at these neutrally, as data points in the file. The files mention Clinton regarding flight logs trips taken on Epstein's plane. They mention Trump in relation to document requests in social circles in Palm Beach.
But neither of them were prosecuted in this case?
No. But the concept of political pressure is all over the files. There is a document that mentions substantial political pressure not to prosecute. Now, in that specific snippet, it's actually contextually linked to Microsoft. It's an analogy used in a legal brief. But the files use it to discuss how high-profile cases work.
It's the atmosphere, right? When you're dealing with a guy who knows presidents, who knows princes, who knows CEOs, the air in the room changes.
It absolutely does. Prosecutors are human. They are ambitious. They have careers. And when they go up against someone with that kind of Rolodex, they know that a wrong move can end their aspirations.
This leads to the idea of a two-tiered justice system.
This is a theme that comes up in the source material, specifically a discussion about plea bargains creating a criminal underclass.
We talked about this before the show. 97% of ordinary cases end in guilty pleas.
Right. Let's do a comparison. If you are an average citizen, let's say you get caught with a bag of weed and an unlicensed firearm in Miami. What happens?
You're in trouble.
The prosecutor slaps 5 charges on you. They threaten you with 20 years. They say, plead guilty today and we'll give you 5. You don't have money for a lawyer. You take the plea because you're terrified. You don't get to negotiate.
But if you're Jeffrey Epstein...
If you are Jeffrey Epstein, you get a sweetheart deal. You get to negotiate the terms of your surrender. You get to dictate where you serve your time. You get to write in immunity for your friends. You sit in a conference room with the U.S. attorney, not a holding cell.
It really highlights that if you have enough money to hire Dershowitz and Starr, you essentially get a different prosecutor than the average citizen. You get a prosecutor who is willing to negotiate.
It's not just a different prosecutor. It's a different legal system, one for the underclass and one for the donor class. The system is designed to process the poor quickly and accommodate the rich slowly.
And the people who paid the price for that two-tiered system were the victims.
This is the most painful part of the files.
The exclusion. The 2008 deal wasn't just bad. It was done behind their backs.
That's a violation of the Crime Victims' Rights Act, the CVRA. Federal law says victims have a right to be informed of plea deals. They have a right to be heard.
But the files mention secret meetings.
Yes. There's a reference to denied meetings with attorneys. The prosecutors were meeting with Epstein's defense team, hammering out this secret NPA, while simultaneously telling the victims' lawyers, we're still working on it, or trust us, we have your best interests at heart.
They misled them. They lied to them.
They essentially colluded with the defense to finalize the deal before the victims could object. They knew that if the victims found out about the NPA, they would challenge it in court. They knew a judge might block it if the victims spoke up. So they kept it secret until the ink was dry.
How did they legally justify that?
They played semantic games. They argued that because the indictment hadn't been officially filed yet, the CVRA didn't apply. They argued that the investigation was ongoing. It was a cynical, technical reading of the law designed to silence the very people they were sworn to protect.
That is a profound betrayal. These prosecutors were supposed to be the victims' champions. They were the ones standing between the predator and the prey. And instead,
they prioritized making the problem go away. They prioritized their own convenience and their own careers over the safety of those girls.
There is a source, Jackie Berger's testimony, that draws a parallel to this kind of thing. Allegations of prosecutors making up charges or dropping them based on external influence. It feels like the same thematic rot. Whether it's cartel influence or billionaire influence, the result is the same. The system bends for the powerful.
And breaks the vulnerable.
So where does this leave us? We have a system that failed spectacularly in 2008 and then tried to correct itself in 2019 only after public shaming.
It leaves us with a lesson about vigilance. The legal system is not a machine that automatically outputs justice. It is run by people. People who can be intimidated. People who can be ambitious, people who can make poor judgments.
And it shows that without the press, without Julie K. Brown, without the people who kept digging, that 2008 deal would have been the end of it.
Epstein would have lived out his days as a wealthy financier, and Maxwell would likely still be a socialite in London. The deal was designed to be the final word. History proved it wasn't.
It's terrifying to think about.
It is. But the files exist. We have them now. And that means we can see exactly how the sausage was made, however unappetizing it is.
So what does this all mean? We've looked at the prosecutors who folded, the ones who fought, and the system that allowed both to happen. We established that the failure wasn't just an accident. It was a series of choices made by specific people in power.
And while some measure of justice was eventually served with Maxwell's conviction, the question of the potential co-conspirators, those people protected by the 2008 deal, still lingers. The deal is gone, but the clock has ticked on.
Next time, we're going to help you do what we've been doing. We're going to give you a guide to the documents, how to read the files, key document types, methodology for researchers. Because there are thousands of pages, and understanding how to navigate them is the only way to find the truth yourself.
It's going to be a practical toolkit for anyone who wants to see the raw data.
That's next time on the Epstein Files.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.